So maybe we can start now, right? Okay.
Okay, excellent. I'll just start. And I should really start by saying thank you very, very much for hosting me. It's an honor to be able to speak to you over there in Hong Kong City. I very much miss, especially now that I no longer live there. It was my home of 7 years. And in fact, as it happens, I happen to live quite close to the campus of City University. And I would like to say also that, of course, I appreciate that there is some it might seem audacious for me to talk about Hong Kong to an audience of Hong Kongers who, of course, in so many ways know so much more about Hong Kong, its legal political system, its society and culture than I do, especially nowadays that I no longer live in Hong Kong. And so forgive me for that. But I should also say that I suppose my purpose in this very short hour that I'm sharing with you, my purpose really is to try and contextualize an outsider's view on Hong Kong in the broader and put it in a broader perspective of what the changes of Hong Kong governance mean for global governance, or what we can learn in a certain sense about China's global governance ambitions and broader global governance trends from the trajectory of the Hong Kong legal system. And you can see from the title that I'm using here that I take a somewhat gloomy view of the trajectory for the rule of law in Hong Kong. So I'll try to do that, but I can only emphasize once more that I'm fully aware of my limitations, and I very much look forward to learning from you. Now, let me try and bring up my next slide. So I would sort of contextualize the trajectory of Hong Kong in by providing a little bit of background of the evolution of China's governance system. And I think that very, very broadly speaking, so far as we are looking at the move from essentially the Mao era to the reform era, I think that we can see how principles that are broadly speaking principles of autocracy, the 人民民主专政 as one of them, the People's Democratic Dictatorship principle as one of them, how these are complemented as China comes out of the Mao era and moves into the 改革开放 era by a very important principle of ruling the country in accordance with law that, from my perspective, although of course we can debate the details of it, is at least envisioning a principle of rule of law. In other words, a principle of limiting government power, of limiting public power by law. And I think that's an incredibly important event, an incredibly important reform that marks the reform, the beginning of the reform era, and that has very, very deep implications for changes in governance in China. Now, having said that, I think that nevertheless, it is also important to see that principles, practices that could broadly be described as lawless, as arbitrary, such as arbitrary incarceration, such as uses of state-centered violence, torture, included therein, and increasingly with technological progress also practices of surveillance and censorship do remain very relevant in governance in mainland China throughout the reform era. And then as we move from sort of away from 改革开放 to 新时代, to the new era that is sort of announced in a certain sense by Xi Jinping, and that is rapidly progressing. I think that if we ask ourselves what the implications are of this new era under Xi Jinping for the evolution of practices and discourses of rule of law in mainland China, I would very broadly say that they have a weakening impact on rule of law in mainland China. And of course, I'm saying this here, understanding the concept of rule of law in a very explicitly and emphatically liberal way, namely, as I just mentioned, the idea of a constraint on public power that has certain that carries with it certain requirements, including separation of powers and basic rights guarantees, and that, for instance, in the perspective of the United Nations, Office of the High Commissioner for Human Rights is also inherently connected to democratic governance, which obviously is something of a challenge for the system of mainland China. There are so many things one could say about the trajectory of this concept of the rule of law in China, and then also of related governance practices in mainland China. But we don't have time to say them all, to discuss this all. But I would, for instance, highlight this very interesting new discourse that emphasizes a combination of ruling the country in accordance with law, 依法治国, with this notion of 以德治国, of ruling by virtue. That is very interesting, but I think from a liberal rule of law perspective, also quite concerning. I would, for example, suggest that we can use the very influential theory of the dual state used by Ernst Fraenkel as an analytical framework to essentially try and conceptualize what happens in changes with sort of changes of discourse and practices in recent years. And of course, Frankel's big argument was that we need to understand governance in some systems as essentially a dual state, where on the one hand, there is law and users of law, that's the normative state, but then also there are arbitrary practices and users of lawlessness, that's the prerogative state. And that, I think, is something that we can to some extent observe in as mainland China's current trajectory. And I will revert to the perspective of mainland China a little bit later, but would like to just spend a bit of time essentially commenting on the evolution in Hong Kong. And of course, I very much hope that I'll be able to do that while also leaving time for a bit of discussion later on. So from my perspective, thinking about Hong Kong, its genesis in what essentially from a mainland China perspective, of course, is the reform era. I think it is absolutely fascinating to remember that in many ways, the Hong Kong special administrative region, as it was created, can be seen as, in one sense, of course, an enclave where rule of law, liberally conceived, is very important to Hong Kong's governance tradition, and where, in particular, basic rights, including those rights which are central to democratic practices, are pretty well protected. And I don't mean to be nostalgic in any way about Hong Kong's origins in colonial era repression, but I think that the overall evolution of the Hong Kong legal system had essentially enhanced protections for basic rights. And of course, a principle of judicial independence. So at the time that the Hong Kong Special Administrative Region is created with all the attendant sort of guarantees and safeguards and the international law entrenchment for Hong Kong's governance for the next 50 years to come. At that time, I think Hong Kong is not just seen in a certain sense as a from a rule of law perspective, more advanced rule of law enclave. But also, I think, and this is something that I'm trying to illustrate here with this article that is interestingly titled, Hong Kong's Influence on China, the Tail That Wags the Dog. At the same time, at this moment in Hong Kong's history, I think, there is also a certain perspective on Hong Kong as a potential model for the evolution of mainland China's legal system. From the perspective of today, that's kind of fascinating. I remember in the early 2000s, mid-2000s, having discussions with colleagues with mainland law professors who basically also articulated this as a potential perspective. The idea that the fact that Hong Kong had reverted to mainland, to Chinese sovereignty, and that it was now a system within a system, that it was it was operating under the principle of one country, two systems, I should say, was potentially quite meaningful for the efforts within mainland China to engage in what at the time would be discussed as 法治建设, but then translated as the construction of the rule of law in the mainland Chinese system. But of course, if we sort of turn to the trajectory of Hong Kong in the new era, and you will forgive me for being very sort of for abbreviating essentially what with more time could be a very interesting discussion of the decades that follow the reversion to sovereignty in Hong Kong and the trajectory of the legal system in Hong Kong under one country, two systems, including the very interesting development of the judiciary. But since we have very little time, I think it might be, we need to sort of fast forward a little bit and examine essentially how Hong Kong gets to the point that it is in now. And I would very broadly, I would say that the hope that Hong Kong might be a model for mainland, but also that Hong Kong itself would, in fulfillment with what appear to be promises held out by the Sino-British Joint Declaration and the Basic Law, that Hong Kong itself would sort of be able to democratize further. These hopes are sustained, I think, throughout the period that we can think of as China's reform and opening era. And as the prospects for reform and opening within China start closing again, I think we can see that Hong Kong's prospects for democratization sort of start waning. And so the Occupy Central movement that is launched 2013, although of course the sort of big events, the sit-ins and so on, happened in 2014. It is hardly surprising from that perspective that they fail. It is, if not surprising, then at least disheartening that in the years that follow these events, we can see how the central authorities in China are sort of essentially stepping back from the international law commitments that had been made, for instance, in the context of the Sino-British Joint Declaration. where in 2017 a spokesperson, I believe it is a government spokesperson, notes that they no longer have meaning, which from an international law perspective is false. And then, of course, as we are all aware, the 2019 protests against a proposed extradition bill really accelerate developments that I would see as a breakdown, a sort of slow motion and then accelerating collapse of very important rule of law principles in Hong Kong. The imposition of the national security law for Hong Kong, not following the provisions for legislation as they are envisaged in the Hong Kong Basic Law, I would very broadly see as an attempt to entrench a system within Hong Kong that takes the Hong Kong governance, closer to a model of dual state by essentially strengthening what Frankel would have called the prerogative state for the Hong Kong Special Administrative Region. And of course, I should have mentioned, although I think there's no need to share in this small group, that to my mind, one of the absolutely emblematic moments and also images of the introduction of the national security law is that image of the protesters that hold up blank sheets of paper. Because the freedom of expression that was so important and so central to governance in Hong Kong is sort of gradually is sort of perceived to be at threat, and these protesters themselves feel threatened. And if we look to the trajectory of Hong Kong following the imposition of the national security law, I mean, I think that there is unfortunately much to that there are unfortunately developments that should make us conclude that these protesters had a point. I think I need not spend much time because you I'm sure are far more expert than I am, but it is of course necessary quickly to mention that the national security law centrally introduces criminal offences, and that among the criticisms of these offences firstly, I think that they are vague, and of course in the context of criminal provisions that is a particular problem. And secondly, that if you look at some of the variants, for instance, for terrorism offences and also for collusion, the offence of collusion with a foreign country, they are not only vague, but also suggest that there are variants that can be realized by merely non-violent activities, such as, for example, non-violent criticism of the government. And I think that further, it is important just quickly to note that there is much concern about the special procedures also introduced by the national security law, and to mention, of course, for instance, the enhanced investigation powers and the sort of weakening of formerly quite strong bail provisions. And perhaps from the perspective of a scholar who, like myself, has spent a lot of time trying to understand the activities and the influence and impact of national security, of what I call the security apparatus in mainland China. I think also that the threat of transfer of jurisdiction to the mainland in certain cases where the national security law, where offenses under the national security law are suspected, is extremely important to understand the impact of this legislation. So here I would perhaps just want to say that I've spent a lot of time, I've spent many years talking to, for instance, human rights lawyers and criminal defense lawyers working in mainland China. And I think that the reality of the system affecting them was always characterized by users of the law, but then also, for instance, the experience of enforced disappearance and the reality of users of police torture that affected very broadly, that affected themselves, their clients, but also could affect themselves. And thinking about and so one of their one of the first challenges in many cases of, for instance, criminal defense lawyers sort of trying to work with their clients in the mainland Chinese system was that they would have to start by looking for their clients. They would have to start by looking for their clients because there would be some problem with not having notified the family of the detained person, of the client, not knowing where they were held, essentially trying to work out where they might be. And of course, while important time was lost looking for your client, all manner of things could happen to that client. And all too often, once they finally got access to a person who then turned out to be held as a criminal suspect under 刑事拘留 or some form of, or 监视居住 or some other form of de facto detention as available under the Chinese criminal procedure law, they would find that the client might have been intimidated or indeed physically or mentally tortured during that time. So I think that background is really important when you think about what it means that the national security law does sort of provide for the possibility of a transfer of jurisdiction to the mainland. Of course, it's not the transfer to a system that explicitly allows in any way the practices that I just mentioned. It certainly doesn't. But the fact that in practice, there are so many flaws of the criminal process in mainland China, of course, really raised, I think, the importance and the sort of scariness of the specter of a transfer of jurisdiction to the mainland. And I mean, if we look to sort of cases of application of the national security law so far, obviously there aren't that many cases that have sort of completed or that have resulted in judicial decisions, I should say, yet. But I think that, I mean, we could, for instance, look at the Dong Ying case, forgive my pronunciation, that was decided earlier this year, that that kind of indicates that at least some of the anxieties around the national security law that were articulated early on really are justified. There is a wonderful study done at Georgetown University that I would really like to recommend to everyone on the verdict in this case, but then also more broadly on the national security law. And I mean, the case is remarkable, I think, in that it does appear to me to be a use of the national security law precisely for the purpose that was most feared, it is essentially draws on the use of the defendant of this very famous slogan, 光复香港时代革命, liberate Hong Kong revolution of our times, and the fact that it results in a sentence of imprisonment for inciting secession and acts of terrorism, I think sadly justifies the fear that the national security law is a piece of legislation available for the persecution, the criminal prosecution and judicial persecution of political dissent. Other decisions indicate that although, of course, importantly, the national security law does make a reference to human rights, to the applicability of human rights principles in its remit, in effect, judicial review of its provisions in light of human rights principles will not be available. And I think we need to sort of think about the broader implications of this. And there are so many things to say, so I'm only going to pick out a couple because I realize that, of course, I not only want to talk about Hong Kong's trajectory, but also try and contextualize a bit. I mean, I think one of the trends that we've seen sort of in the run-up to and then in the wake of the national security law, from my perspective, really is that there's a kind of normalization of state-centered violence. And I think we can see that in the widely discussed uses of, for instance, these police batons and police violence in the context of protests. And what is concerning here is not only that fairly violent strategies and tactics are used for by the police, but also that the judiciary appears to have become very, very hesitant to actually effectively review these uses of violence. And so, for instance, I feature here a tweet from only yesterday where a judge apparently said that the description of a police baton as a weapon was problematic. When we see that in light of, as Anthony Depirin sort of points out here on this on the little picture that you can see on the slide, of the fact that plastic bottles, on the other hand, have been regarded as weapons. I think that this is quite symbolic of a sense that there is an increasing imbalance, a loss of impartiality going on in the practice of the judiciary in handling these cases. But more broadly, of course, as you can see from the holding up of these white papers and many other responses within Hong Kong society, the criminal provisions of the national security law and changing judicial practices and police practices, I think, have had a broadly chilling effect. And as of course has, in my perspective, the presence of mainland national security officials in Hong Kong who cannot be subjected to the same level of scrutiny. So from a dual state perspective, how would we analyze that? I mean, I think that it means a kind of widening of zones of lawlessness. It means a raising of the specter of the arbitrary state or the prerogative state. And that's very concerning, and it's concerning, of course, also because we see we see broader developments, and I think that very sort of in the wake of the national security law, that it sort of target perhaps not so much the legal and judicial process as such, but the broader socio-political and legal conditions on which the practice of rule of law in any society depends. And of course, as I mentioned earlier on, if we think of rule of law as an essentially liberal idea, we have with the United Nations and others to recognize that it is connected also to democracy, to the values and principles of democracy. It depends on the availability of democratic dissent as much as on the availability of civil society exercising important basic rights and scrutinizing government action. And so we've seen, sadly, a quashing of democratic dissent. I think I mentioned the Jimmy Lai case already, but of course there have been many other cases, far, far more than could be enumerated, of arrests under the national security law, and also of accusations that certain democratic actors, or oppositional actors, I should say, in Hong Kong were acting in violation of the national security law that contribute to this law's chilling effect. And on the other hand, there has been a trend towards suppression of civil society that appears to be, from my understanding, often triggered by, for instance, merely sending requests for crucial information from the police or the national security, the officials in charge of implementing the national security law, to certain human rights organizations, think tanks, civil society organizations, requests that in light of the legal developments under the national security law can in some cases prompt civil society organizations to decide that it is time to disband before they are sort of formally speaking targeted, or before their members are targeted by sort of the most scary measures, such as a criminal arrest. And so we've seen, I mean, a very wide variety of organizations affected in this way. I suppose that one NGO that indirectly I already mentioned by referencing its report on police violence, Amnesty International, the Hong Kong offices of Amnesty International, is just one example, but then there are many local, smaller NGOs working on issues of human rights in Hong Kong and in mainland China that unfortunately have also been affected. And I think that, of course, there have also been sort of more, I mean, further or related, I should say, steps that have diminished democratic opposition in Hong Kong. Most centrally, I suppose one needs to mention the ouster of democratic lawmakers and this idea that there must be a requirement of political loyalty to the central Chinese party state as a requirement of sort of as to qualify as a legislator in Hong Kong. And a further example would be, I think, the extension of at least threats beyond Hong Kong, also to, for instance, the Danish lawmakers that were trying to assist Ted Hui. And then lastly, and I will just I will not go into this because I'm very conscious of time, I would mention the fact that there is the most recent reforms and reform discussions have included seem to be addressing the potential for further affecting the potential composition and the behavior, the principles governing the judiciary. There is, I think, much left unclear about the potential for changing the judiciary in Hong Kong more profoundly than it has changed already. But one of the examples probably to mention would be changes to the legal aid system that make it that at least affect the judicial process overall by diminishing the right to be represented by a lawyer of one's own choosing, that is so central to fair trial guarantees. So what to make of this overall, if you sort of try to take stock of the trajectory for the rule of law in Hong Kong, I mean, I think that it is impressive that in many ways, if we think of Hong Kong as a system of separation, of some separation of powers, it is impressive to see how in some ways the judiciary has held up, and it has been less affected by changes, by the changes of the past few years. But I think that the establishment of something of a two-track system, and in particular the importation, if you like, of zones of arbitrariness, of lawlessness, zones where judicial scrutiny of executive action, including police uses of the coercive force of the state by the police, is not available or less available, combined with the chilling, the intimidating effects of the national security law and surrounding practices, combined with what I think we must call techniques and tactics of rule by fear. If we sort of look to these trajectories and trends in Hong Kong, then I would say that that the rule of law has been very clearly very much weakened in what is, after all, a very short few years. And I think that if we try to draw lessons from how the situation with regard to rule of law, with regard to legal protections has evolved in mainland China, I think that the trajectory for Hong Kong is quite bad, because after all, in addition to the institutional changes, which in Hong Kong's case were introduced quite quickly, the kind of medium and long-term effects of sustained repression of civil society and sustained uses of intimidation in the ways I just tried to describe. These effects, I think, do not materialize instantly, but I do think that rule by fear techniques are going to become more pervasive in Hong Kong, at least in the immediately foreseeable future. So that's all terribly concerning. And I suppose, I mean, I have not at this point mentioned the implications of all of this for our professional field, for academia, but I think it's quite obvious from my perspective anyway, that there are these implications, that sort of both the reach of the coercive state and the criminally prosecuting state into academia, including into legal academia, the criminal conviction of Benny Dai, although of course not under the national security law, and the kind of broader chilling, intimidating effect that the national security law has had on academia is pretty obvious. I think that as a very, very sort of brief tentative attempt to think of this in the context of broader changes in global governance. I mean, we could, on the one hand, look to China's ambition to essentially make a contribution to what it calls a community of shared future, what it refers to as essentially a situation of globalization, of 你中有我, 我中有你, that is where China is expected to take a more important place in accordance with its very clearly rising economic and broader geopolitical power. So, I mean, I think that if we look to China's ambitions, I would broadly speaking say, firstly, that China's ambition is, I think, to deliberalize international law, to sort of weaken liberal principles in the international legal order. We can see that in its various in the various attempts to push a kind of a set of principles that either completely obliterates or weakens, for instance, the role of rights and principles central to the practice of democracy, such as freedom of expression, etc. We can also see it in the this would be my second point, in an enhanced and I'd say overall more assertive emphasis of principles of national security combined with territorial integrity as it is seen from the perspective of the central Chinese party state. For such a long time, there was this narrative that the principle of one country, two systems would be attractive for the people of Taiwan as sort of outlining a potential trajectory for a reunification. That's clearly gone, I think, but at the same time, obviously, China, the Chinese central party state remains assertive about its conception of Taiwan as a part of Chinese territory. And I think we can see that perhaps we shouldn't spend the time to listen to Wang Yi, but we can see that, for instance, in what Wang Yi says in defense of the national security law at the international level, and of course also in Xi Jinping's thoughts and ideas for global governance. But I think it's also important to see that, to see these changes within China, within China's outlook on global governance in a broader context. And there, of course, I think that the weakening of international law liberally conceived, or if you like, of the international rule of law as a principle of global governance, is as much affected by what happens in China or how China is changing, as it is also affected by what various scholars have called democratic retrogression and autocratic legalism and populism and so on. And so I think it's really important to see that these trends, the deepening of authoritarianism, if you like, an emergence of neo-totalitarian conceptions of governance in China and their impact on the international law system on global governance is complemented by the weakening of liberal democracy in many places. For instance, I mean, one very prominent and important example, of course, would have been Trump era, sort of the United States under the Trump administration. So I think that in conclusion, I would basically say that I think that that indicates that Hong Kong's experience, broadly an experience of authoritarian closure and weakening rule of law, is emblematic of a very complex global trend to which China, the central authorities of China contribute, but are not the only contributor. And I think I would like to stop here, leaving a few minutes for discussion. Thank you very much.
Okay, thank you very much, Professor Pils, for the wonderful lecture that we have heard. And we are very thankful that our director of our Judicial Legal Research Center, Professor Lin Feng, is here. And we will first invite Professor Lin Feng to serve as a commentator to give a very brief comment on the speech. Professor Lin Feng, please have the floor.
Thank you, Tianxiang. And I would like also to thank Eva to giving us a very interesting lecture talking from Hong Kong to China to global governance. It's given us very many ideas for further thinking. Look at Hong Kong, just mention a couple of points. I think what Eva has mentioned, shown to us that Hong Kong is a very interesting example for research. In Hong Kong, from what we've heard, and actually if we look at from the perspective of Western liberal democracy, it's very clear that democracy, you can say, it has been weakened. Okay, I think that's a conclusion everyone by using the same standard, the Western liberal democracy you will come to. But this gives us materials for thinking. Is if you look at over the years in the research or academic discussion about issues in Hong Kong, or constitutional issues in Hong Kong, you can see there exists two different narratives or discourses. And when Hong Kong scholars or Western scholars have academic discussions with Chinese constitutional scholars, there is not much engagement. Actually, each group is talking about the issues by using their own discourse or their own narrative. So that is an issue, I think, because we are living in Hong Kong, and how we can bridge the gap between the two, and really trying to get the scholars on both sides to engage on the issue. Whether we can achieve that, I'm not sure. And because from their perspective, they come out with a different, completely different narrative. And because you can clearly see, like from last year's, from the 2019, I would say the movement, you can call it, and up to this year's election reform, it's a fundamental change of the system. And what I call it is a sort of constitutional resetting. Because now, in their view, they're saying, no, the system, if we allow the system to develop further, then we'll lose the control in Hong Kong. So that's their issue. That's their sort of, you can say, a bottom line. So that's why they have come up with the sort of patriots ruling Hong Kong. So have the sort of candidate scrutiny process there. So it's very clear, anyone who's against the system will not be allowed into the system. So that's a sort of, you can say, red line. If you're against the system, then okay, you can oppose the system outside the system, but don't come into the system. We will not allow you to come into the system. So that's a sort of, you can say, fundamental change of the rules of the game in Hong Kong. Okay. So as to the future, how it will actually impact, and whether there will be loosening by following the Western approach, let's say 10 years down the line, and whether something will change. We don't know. We still need to wait and see. My personal guess is that it's possible. It's possible, because I think their view is a sort of stability. They want to have stability in Hong Kong, and then look at the other issues. So how it will develop is something I think we all are concerned with. But the other issue, that in the final conclusion, I think you've raised a very important issue, that is, what will be the future actually? Hong Kong is just one example. What will be the future of governance in Hong Kong, in China, in actually throughout the world? And how the system in our training, Western democracy, liberal democracy, whether that's the best model for the domestic governance or even international governance. And you mentioned the Trump era, that shows a sort of extreme example. But most countries will say the liberal democracy is still working reasonably well. So whether any changes should be made and what sort of changes should be made, and whether Chinese model will provide an alternative. And I think those are the issues academics we need to seriously consider. And myself, I don't have any answer to those. I'm still focusing on the specific issues of the NSL, and because the whole implication of it still need to be revealed through the cases, and through sort of judicial litigation now, step by step, we know certain areas getting clarified, and whether those are good or bad, and we can discuss further. But at least certain areas we know, oh, the rules are now, courts have made the decisions. But there are still many areas there it's ambiguous. So we need those. I think I will stop here and to allow other people to ask questions. Yeah.
Thank you, Professor Lin. Eva, you want to have some brief reply?
Just 1 minute. Thank you so much for these wonderful comments. I'm really deeply grateful to have the attention of such a wonderful scholar. Thank you very much, Professor Lin. I think that I would very quickly say that I think that it's true. I agree that this is an attempt by the central authorities to essentially regain control. And I think that in some ways we could say that the way the Hong Kong system had set up meant a kind of inherent instability. But I think that, of course, in many ways, instability was also part of the promise that we can find, for instance, in the Basic Law and in the Sino-British Joint Declaration, a promise that future further democratization would be allowed. So in that sense, I think it is very important to take that on board. And I think that from the perspective, of course, of, for instance, pro-democracy advocates in Hong Kong, they would very much want to emphasize that they are not against the system as it had been set up, with its inherent implicit promise of further democratic trajectory, but rather that the system has been changed by ejecting them. I also very much agree that the future of global governance at the moment is sort of in the balance, that we do not know how things will evolve, and that democracy as a model is very dramatically challenged. I see that as something we absolutely need to study, although I have to admit that on the basis of my own engagement with governance in mainland China, in particular, and engagement with human rights defenders and dissidents and so on, I would say that I don't think that the system that is practiced in mainland China is an attractive alternative, although very clearly I very much agree that it is an alternative to be taken seriously. Thank you.
Thank you, Professor Pils. I see that we have some colleagues and students in the audience as well. So if there are any extra questions, please feel free to ask. And I hope that we could have some extra questions.
I have a question. Can I ask?
Yes, please. Yes.
Okay, thanks for the talk, Eva. My question is, what do you think of the role of the masses or the people in Xi Jinping's political agenda? And what's the role of the Maoism in Xi era? And also, what's the connection of the Maoism or Xiism and the global resurgence of the populism? Thank you very much.
Oh, thank you very much. That's really interesting. Well, fascinating. So very briefly, I'd say that I think that when we talk about the people, from the perspective both of the Chinese party state and of populists like, say, Trump, it's fascinating to and important to consider that the people are, of course, conceived in a very homogenic way. From these perspectives, in the case of populists, they use that as part of their, they tend to use that as part of their election campaigns, as when Trump basically says, the only people who matter are the people who support me, others don't really count, etc., etc. I think in some ways we can see a Renmin conception of people versus a Gongmin conception of people also reflected in the contention between the Chinese party state, the official party state, so much influenced, as your question hints, by Mao Zedong, by Mao Zedong thought on the one hand, and on the other hand, democracy and human rights activists in mainland China. Such as the New Citizen Movement, 新公民运动. So in a sense, a citizen versus a homogenic people conception of individuals is very much central to governance in mainland China. I do not think that the attempt to homogenize the people to one sort of Renmin is likely to be fully successful anywhere. Certainly not in current liberal democracies, but certainly also not fully in mainland China, where we can see that dissident voices do manage to be articulated despite the ramped up repression under Xi Jinping. The relationship between Mao and Maoism, or yeah, I think you said Maoism and Xiism, I'd say a very important difference from my perspective is that China in its current era has created a legal system that couldn't possibly be sort of completely eliminated or rhetorically diminished to the extent that the idea of law was diminished in the Mao era. And I think that has important causes and reasons, for instance, in China's global interconnectedness, also with a global economy as well as a global governance system. But also, of course, it has really important implications to how far Xiism, to use this lovely phrase you have used there, Jiang Jue, could evolve. Thank you.
Thank you very much. Yes, we
Sorry.
have still more question. Yes, please.
Hi, thank you so much, Professor Pils, for the excellent seminar. So I just have a very quick question for you. So at the very beginning of your speech, you talked about rule of law and rule by virtue. And now, of course, in political science, the idea of the rule of law and rule by virtue has to do with the theme of moderation, right? So how do you moderate, political power? How do you moderate state power? Is it through the rule of law or is it through the rule by virtue? But when we talk about, when the idea of rule by virtue is talked about nowadays, especially, by Xi Jinping, right? Do you see him using rule by virtue as, in a moderative way, or is it just, a populistic slogan? It seems that, that there is this discourse and the way that he was behaving, he is trying to do away with shackles, but not, trying to moderate the power that he has. Thank you.
Oh, I see. Thank you so much. Yeah, that's really fascinating. So I think that I basically agree with you. I think that this particular way of deploying this phrase 以德治国 really is not to add to the constraints on public power, but rather to remove the constraints of law on public power by essentially claiming that it is okay for the state to intervene, or the party to intervene, for instance, to sanction conduct, not on the grounds that it has violated law, but on the grounds that it is against virtue, and to educate everyone, for instance, on the basis of sort of conceptions of what is correct political thinking. So when you think about deployments of, say, or this vision of the social credit system and the many, many practices that are already in place that are related to this broad idea, when you think about political education, such as is now also demanded in Hong Kong, but is of course absolutely pervasive in mainland China. I think all of these and also the sanctioning the censorship, be it by means of legal rules or by means of technological intervention of public discourses in mainland China on the grounds that they are somehow against morality or against virtue. I think all of these are examples that basically show that ruling with virtue is a tool. It's a concept that the state can use to justify going beyond the law in seeking to regulate and perhaps sanction and punish citizens' conduct.
Thank you. That's very insightful. Thank you so much.
Okay, thanks very much. Are there any more questions from the audience? So if not, I think we should conclude in here. And thanks very much for Professor Pils' contribution to the lecture. And it's a really wonderful chance that we could have scholars in audience to discuss this very important issue to Hong Kong. Albeit it's a little bit sensitive, but I think it's okay if we discuss in a academic way, right? So
in a very scholarly setting, of course.
Yes, thanks very much.
Thank you very much. Thank you so much for the invitation. Thank you for letting me present and for your comments. Thank you.
Thanks.
Thank you very much. Yes.
Thank you,
I hope
Professor
to
Lin.
see you in the future in Hong Kong.
That would be
physically.
wonderful. Thank you, Professor He, as well. Thank you. Bye-bye.